Hey everybody, Happy New Year. We are back in the Shanty for the first time in 2024. Been doing this over 3 years now. So we're back for the first time in 2024. It's a beautiful winter day outside. The snow is coming down. My faithful dog is laying at my feet wanting to go out and chase the squirrels. But we're back for the start of a new year, and we have our very first new labor law, employment law rule, which is not really a new rule at all. Have you ever gone to a tennis match and seen a tennis match live? I had a couple of kids that played tennis in high school many, many years ago. Or a ping pong match where you're doing this, and then this, and then this, and then this, and then this. That seems to me like what we're doing with the Department of Labor. We have the Obama administration, and then the Trump administration, and then the Biden administration, and who knows what the next administration is going to be. But we keep going back and forth and back and forth and back and forth. And this seems to hit us in labor and employment law. Maybe more than anywhere else, where we just keep changing back and forth. Now, those of you that have dealt with unions and the NLRB have been dealing with this for years and years and years, because the NLRB precedent doesn't mean anything to them, and they flip back and forth with administrations. We're now dealing with the same thing with the Department of Labor and the Wage Hour Division, and the rule that we're talking about now is who is an employee and who is an independent contractor. So today, January 9, the Department of Labor announced that they are issuing a new final rule on who is and who is not an independent contractor under the Fair Labor Standards Act. Really what they've done is gone back to the old standard before the Trump rule. So let me just read you the press release, okay? On January 9, 2024, the U.S. Department of Labor announced a final rule effective March 11, 2024. So this rule, it's going to be published actually tomorrow in the Federal Register. It will be effective on March 11, 2024, revising the department's guidance on how to analyze who is an employee or independent contractor under the Fair Labor Standards Act. This final rule rescinds the independent contractor status under the Fair Labor Standards Act rule, 2021 IC rule, that was published on January 7, 2021, and replaces it with an analysis for determining employee or independent contractor status that is more consistent with the FLSA as interpreted by longstanding judicial precedent. The press release goes on to say the misclassification of employees as independent contractors may deny workers minimum wage, overtime pay, and other protections. This final rule will reduce the risk that employees are misclassified as independent contractors while providing a consistent approach for businesses that engage with individuals who are in business for themselves. Okay, so that's what the press release says. And then you can actually go to the unpublished rule, which won't be published until tomorrow. Well, the unpublished rule is 339 pages long. So we're not going to go to the unpublished rule. We are going to go to the frequently asked questions because they're considerably shorter than the unpublished rule. And we're going to get right to the heart of it. I don't want to spend a ton of time on this. And we'll go to question number 7, the substance of the final rule. That's really what we're interested in here, right? What is the test? Okay, we've got the IRS 20-factor test that was out there for years and years. What is the Department of Labor's test going to be? And it's going to sound very familiar to some of you because, as they point out in the press release, it's the old rule. So, question number 7 of the frequently asked questions on this topic asks, what analysis guides whether a worker is an employee or an independent contractor under this final rule? And here's what the Department of Labor says about that. This final rule continues to affirm that a worker is not an independent contractor if they are, as a matter of economic reality, economically dependent on an employer for work. Basically, what they're saying there is if you are an independent contractor who works for one employer full-time, they're your only client, you're probably not an independent contractor because you are economically dependent on that single employer. Now, that's not the whole test, but that's the gist of it, right? The economic reality. Consistent with judicial precedent, the department's interpretive guidance prior to 2021, the final rule applies the following 6 factors to analyze employee or independent contractor under the FLSA. Number 1, opportunity for profit or loss depending on managerial skill. Number 2, investments by workers and the potential employer. Number 3, the degree of permanence of the work relationship. Number 4, the nature and degree of control. Number 5, the extent to which the work performed is an integral part of the potential employer's business. And number 6, skill and initiative. And then the DOL goes on to say the following. The final rule provides detailed guidance regarding the application of each of these 6 factors. No factor or set of factors among this list of 6 has a predetermined weight, and additional factors may be relevant if such factors in some way indicate whether the worker is in business for themselves, i.e. an independent contractor, as opposed to being economically dependent on the employer for work, i.e. an employee under the FLSA. Okay? So, that should sound very, very familiar to you. It should sound very, very familiar to you. But there's 2 other questions, okay, that I want to cover briefly. Number 1, question number 9 is, how is the final rule similar to the department's 2021 independent contractor rule? And what the DOL is saying here is, look, we didn't completely shift gears and go in 180 degrees in the opposite direction. There are similarities. And they point out, for example, that both rules advise that independent contractors who are workers, quote, as a matter of economic reality, are in business for themselves. The Trump administration rule had the same thing, but the Trump administration rule focused on 2 specific factors as kind of key factors, guiding factors. This rule doesn't do this. And that gets us to the next question. How does the final rule differ from the department's 2021 independent contractor rule? And here's what the DOL says about that. It returns to the totality of circumstances economic realities test, where no single factor has any more weight than any other single factor. You have to look at all of the totality of the circumstances. In other words, there's no bright line rule. You have to consider 6 factors instead of 5. There's additional analysis, blah, blah, blah. That's how the rule is similar. So really, here's what we've got. We've gone back to where we were for about 40 years before the Trump administration changed the rule. Now, this, as I said, the final rule is going to be published tomorrow. It's going to go into effect on March 11th. Is it going to be the final rule? I don't know. It seems like the last 5 or 6 times stuff like this has happened, somebody's gone and sued and challenged it. For example, when the Trump rule went into effect, the Biden administration immediately issued a rule rescinding the Trump rule. They were sued in the 5th Circuit in Texas, where these things are always brought now. The judge in Texas said, you can't do that. You have to follow the actual administrative rulemaking process. You just can't issue a rule rescinding a rule. So that's why we are where we are now. This final rule followed the actual administrative rulemaking process. And what do I mean by that? Well, what I mean by that is they issued a proposed rule and they asked for comments. By the way, 55,400 comments on the proposed rule. They took into account all the comments, and then we get this final rule as a result of that. Now, there's one other thing that I want to remind you of, and the DOL reminds us of this in the FAQ. The other thing I want to remind you of is In order for a worker to be an independent contractor under this rule, they have to meet the test. An employee cannot waive their rights under the Fair Labor Standards Act, which means they cannot waive their right to be classified as an employee if they're supposed to be an employee. So if you've got some guy working for you who's been working for you for 10 years and he decides, hey, I'm going to be an independent contractor because I don't want taxes taken out of my check anymore, and I don't want to have to worry about this, and you like it because now you don't have to worry about overtime and all that, and you guys enter into a contract, and he's doing the exact same job for you now that he was doing for you before. He's probably not an independent contractor because he's not in business for himself, and he's economically dependent on you. They have to meet the test, and here's exactly what the DOL says about that. Can a worker voluntarily waive employee status and choose to be classified as an independent contractor? And the Department of Labor says no. Under the FLSA, a worker is an employee and not an independent contractor if they are, as a matter of economic reality, economically dependent on the employer for work. While businesses are certainly able to organize their business as they prefer, consistent with applicable laws, and workers are free to choose which work opportunities are most suitable for them. If a worker is an employee under the FLSA, they cannot waive FLSA protected rights such as minimum wage or overtime. The Supreme Court has explained that permitting employees to waive their FLSA rights would harm other employees and undermine the Act's goal of eliminating unfair methods of competition in commerce. Period, end quote. In other words, if you're going to hire an independent contractor, they have to meet these tests. They basically have to be in business for themselves, okay? And you have to walk through those 6 things, and the totality of the circumstances has to indicate that the economic realities show that they are an independent contractor. And signing them to a contract and having them do the exact same work they were doing for you as an employee is probably not going to be good enough. That's our first one for 2024. I hope you all have a wonderful, fruitful, happy new year, and we'll see you next time.